Good morning, afternoon, or evening to everyone present. Thank you all for coming to the fourth edition of the International Law and Social Science Speaker Series, which is organized jointly by the American Society of International Law, Interest Group on International Law and Social Science, and the European Society of International Law, Interest Group on Social Sciences and International Law. I'm Zuzana Godzimirska. I'm Associate Professor of Human Rights and International Institutions at ICORT, Center of Excellence for International Courts at the University of Copenhagen. I'm also co-convener of the EASL Interest Group on Social Sciences and International Law, and I'll be chairing the session in that capacity. Our speakers today are Silje Hermansen and Erik Voeten. So Silje is Assistant Professor at the Political Science Department at the University of Copenhagen. She holds experience from both pluri-courts at the University of Oslo and I-courts at the University of Copenhagen. And in her research, she's focused on the selection and behavior of legislators and judges at the European Parliament and the Court of Justice of the EU, respectively. Erik Voeten, in turn, is the Peter F. Pro Professor of Geopolitics and Justice and World Affairs at Georgetown University's Edmund A. Walsh School of Foreign Service and Government Department. He's also the director of the Mortara Center for International Studies and has been editor of journals like I.O. and Research in Politics. In his research, Erik has examined the role of international institutions and law in international affairs, and his recent book, Ideology and International Institutions, offers a theoretical framework for understanding how social, economic, and political conflicts influence international institutions and their place in the global order. In today's presentation, Silje and Erik merge their respective strands of research and present their joint ongoing work on the effect of ideology on court rulings by focusing in particular on the role of judges in state aid litigation before the Court of Justice of the EU. Grein de Burca had originally kindly accepted to act as discussant for today's session, but was unfortunately prevented from participating at the very last minute. And we've tried to find a suitable replacement, but haven't succeeded. And so instead of a discussant today, I'll give Silje and Erik 25 minutes to present their work, and then I'll open up directly for questions from the audience. If you're in the audience and have a question, big or small, I'll kindly ask you to submit it through the Q&A. That is not the chat, but the Q&A function in Zoom. And then I will do my best to get through them all within the time that we have at our disposal. Like the other sessions in the speaker series, note that today's session is recorded, and the recording will be made available on EASL's YouTube channel subsequently. All right. So without further ado, Silje and Erik, the floor is yours.
Thanks so much, Zuzana, for the kind introduction and also for the invitation to speak here in this forum. I'm going to share my screen a little bit. I should also apologize for not sharing a paper in advance. Silje and I used this opportunity to get our paper sort of written, and there is a draft if people are really interested, but it's not quite complete yet. But we hope to be able to share it very soon. So this is very much research in progress, so we really do appreciate any comments and suggestions you may have, as it can really shape the research that we're doing right now. All right. So I hope this is visible. So our paper sort of starts with the observation that there are a bunch of questions in the broader judicial behavior literature that are very prominent there, but are not often asked in the context of the Court of Justice of the European Union. So one is whether governments can influence the court's ideological direction through the appointment process. And another one is whether the internal organization of the court affects case outcomes. And the reason we think that these questions don't really play a big role in the Court of Justice of the European Union literature is because of the absence of data. That is, on other courts, the court publishes dissents, whereas the Court of Justice of the European Union publishes judgments as a collective. And so it's hard to know whether individual judges have different views from the majority, what the divisions among the judges are. And if we don't really know much about the divisions among judges, then it's also really hard to study whether the internal organization of the court affects case outcomes. So, for example, we know that the ECJ allocates a lot of responsibility to a rapporteur or a reporting judge, But in the literature so far, that's mostly been studied from the perspective of enhancing efficiency or enhancing sort of the procedural aspects of the court, but not really in terms of affecting case outcomes. Now, in our view, again, this has more to do with a lack of data than a lack of relevance. So in the Court of Justice of the European Union, governments are individually responsible for judicial appointments, one judge on the Court of Justice and two on the General Court. There is a committee, of course, that vets the qualifications of these appointments, but still it ultimately remains a responsibility for governments. We also think that ideology can be important. The court has a lot of important rulings over the rights of European states to intervene in the single market and to intervene in markets more generally. That's also an ideological division that's been very important in European politics, where different governments have differing views about how much governments should be allowed to intervene in markets. And we think that if this is so, there's very little reason for governments, when they're in power, not to appoint justices that at least subscribe somewhat to these ideological visions. So in other words, if you have a more economically left-wing government, that government has the opportunity to select a judge from its networks, maybe its party membership or so, that has at least some shared ideas about what the role of the state in the economy should be. And we understand, of course, that each government only appoints one of 27 judges, but this is not a collective appointment process. Like for every government, it is still, so, when we think about coordination problems like driving on the left or the right, it's better to drive on the left when everybody else drives on the left than drive on the right when everybody else drives on the right. But when you're a left-wing government, it's always better to appoint a left-wing judge, even if it doesn't necessarily immediately change the overall court that much. So we think this should matter. And so there should be judges that have different sort of perspectives on what the appropriate role of the state in the market should be. And we also think that on the Court of Justice, there's actually a lot of delegation to small panels in the court, and especially to reporting judges. So, for example, there's a really large literature on the US Supreme Court that analyzes the role of the judge who writes the majority opinion. But on the Supreme Court, the allocation of the responsibility to draft an initial opinion is only done after the justices have already done a straw poll. So the judges already know who's in the majority, who's in the minority. And then one of the judges in the majority gets assigned the responsibility to draft the opinion. And that gives the opinion writer the potential to influence legal reasoning, but not really the disposition of cases, because that's already been pretty much decided in the initial votes. By contrast, in the Court of Justice, the rapporteur is appointed by the president of the court right from the beginning. The rapporteur first summarizes the written proceedings, and then later on is assigned the responsibility to draft an initial opinion. So we don't yet know if the rapporteur is really going to be in the majority on the case. And of course, the court never publishes this, so we will never really know. But that gives the rapporteur a lot of leverage, potentially over the outcome of cases on the court. And in fact, if you read some of the more qualitative literature on the court, there seems to be a lot of deference to the reporting judge on a lot of cases. That's at least the impression people have. Now, obviously, that wouldn't matter if we think that judges all have shared collective objectives, like enhancing the legitimacy of the court or furthering European integration, where some people argue that the court has a neoliberal bias, so that the judges overall are more sort of leaning towards pro-market interpretations of EU law. If that's the case, if the judges really are a collective, then who is the reporting judge shouldn't really matter for the disposition of cases. But if that's not the case, so if economically more left-wing judges look in a more lenient way towards state aids or state interventions into the economy than economically more right-wing judges, then knowing who the reporting judge is might actually give us some leverage on understanding how a case might be decided. So in this paper, Silje and I sort of try to make both a theoretical contribution to this debate and also an empirical one. So I'm going to discuss a little bit a simple formal model where we look at the potential theoretical role of reporting judges. And then Silje is going to illustrate sort of our initial work with an empirical case, namely the annulment of state aid's decision. So what we're looking at is there's European Commission decisions on whether a case of state aid should be allowed. In general, state aid is prohibited by the EU. But there are some exceptions that are defined. The Commission makes these determinations whether a state aid instance should be allowed or not, but then that can be challenged before the General Court in first instance and then appealed later to the Court of Justice. And those challenges can come from governments, but also from private actors. So if a case of state aid is denied, then a private actor can sue the Commission in front of the General Court. But also a competitor of a company that has received state aid can challenge a decision to allow state aid in front of the General Court. So, for example, there are some high-profile cases on COVID where Ryanair challenges state aid approvals to Lufthansa and KLM, arguing that these instances of state aid sort of interfere with free competition in the European single market. And Ryanair won a lot of those cases. And one reason we picked this sort of specific topic area is partially because I think it's increasingly becoming important with more industrial policy and more debates over the appropriate role of the state in market interventions. But also because it gives us a good case to look at clear ideological conflict that is relevant in both politics in Europe, as well as the judicial sort of the kind of cases that come in front of the court. So what I'm going to do is I'm going to walk you through sort of in a simple way through this model that we are developing. That's based on a model by Cameron and Lax. Was developed for the Supreme Court context, but we're actually adjusting it for the Court of Justice. All right, so what we're doing is this case-based model where there are cases that emerge in front of the court that each have different legal facts. And the courts decide these cases based on legal rules. But these legal rules are somewhat stochastic. That is, a legal rule has an influence on others, on other national courts, on policymakers. But some legal rules are more precise and better motivated than others. And a rule that's less precise has more variance. So its interpretation will differ a lot. So a legal rule has a mean and a variance. The variance is 1 minus q. And what these legal rules do is they define cut points such that a court rejects a state aid case for cases that exceed the cut point and accepts them for cases that fall below the cut point. So basically what you can think of this here is we have some dimensions, say from people who think the court should be more lenient towards instances of state aid versus people who are really libertarians who believe that the single market should be that state aid really should be very exceptional and allowed in very exceptional cases only. And cases sort of fall along that spectrum somewhere as well. Some have better legal justification, some have less legal justification. And what we argue is that justices have preferences over these legal rules, not over cases. So this deviates a lot from the existing literature on government influence on the court, which tends to focus on the importance of the litigants or government observations that are really specific to a case. But we're really interested in more sort of ideological conflict over what the appropriate legal rule should be. Where should the cut point lie, right? And if you think it's more to the right, then you're more skeptical of state aid cases. And if you think it should be more to the left, then you're more receptive typically to government arguments that an instance of state aid should be allowed. And so opinions basically consist of a target cut point, so where the judge sort of defines what the legal rule is or should be. But they also vary in quality. So if you have a higher quality, you reduce the variance of how the decision is being interpreted sort of downstream. Right? So a judge that invests a lot in writing a legal opinion that's very precise and clear and well justified means that sort of downstream by the implementation by national courts and other actors is going to be more precisely focused on that cut point. And we also assume that writing high quality opinions is costly. So producing an extra unit of Q has a certain cost associated with it. but that some judges, maybe more experienced judges or more expert judges, find it easier to write high-quality judgments than other judges. Right? So judges vary in their cost of producing high-quality judgments. And then procedurally, we assume that the reporter judge must write the first draft, but others can amend it, right? So the only advantage that the reporter judge has in this model is going first. So the reporter judge just drafts an opinion, others can adjust it, can even write an entirely new opinion, and then there's a vote. So we're assuming no sort of special role in that sense for the reporter judge, other than the obligation for the reporter judge to write the first draft of an opinion. And so we're just going to illustrate this graphically. So when you're thinking about it, sort of typically when we're looking at panels of judges, we would think that with majority rule, the median judge is the decider. And what I've drawn here is sort of on the horizontal axis, we have judges that can vary in how much they favor state interventions, more towards the left, or more pro-single market on the right, and the quality of the judgment. So the median judge is indifferent between judges that are right at its ideal point, but not of very high quality. And then, as the opinion moves further from the judge's ideal point, the opinion would have to be of higher quality to be of equal utility to the judge, right? So you're willing to make a little bit of a trade-off. You'd like an opinion of higher quality, and you're willing to accept that if it removes a little bit from your ideal point, but up to a limit, right? If the opinion is too far on, say, the pro-single market side, and of superb quality, a judge would no longer accept it. So that's an indifference curve, which basically means that sort of along this line, the judge would be indifferent to different kinds of proposals, depending on where they put the cut point and what the quality of the judgment is. But in writing opinions, it's sort of the opposite, because writing opinions is costly, so you're going to invest more if you can actually get the opinion right at your ideal point. And what that means is that there's an area, that there's a possibility for a reporter judge who comes in, say a reporter judge is more towards the right, to write an opinion that's somewhere between his or her ideal point and the ideal point of the median judge, that the median judge would prefer over going through the cost of writing a new opinion or amending the draft opinion. And so the key intuition here is sort of it would be ideal for the median judge if a reporter judge just writes the perfect opinion that's right at their ideal point. But they might be willing to accept something that's a little bit further to the right if it's of sufficiently high quality. And that's the trade-off that's embedded in this particular model. And an implication of this is that there are cases that are sort of the legal facts are between the ideal points of the median judge and the reporter judge that would be decided differently depending on who the reporting judge is, right? So if the reporting judge is a little bit more towards the right, there are cases that sort of that would be rejected, where state aid would be rejected, compared to a model where just the median judge is the deciding judge. And if the reporting judge is more towards the left, there's a range of cases where state aid would be accepted, but that would have been rejected if the median judge were the decider. So that's the idea that the reporter judge can matter just by going first, and by being incentivized to write an opinion of sufficiently high quality to persuade the median judge to go along with it. And one analogy that might appeal to academics is, like, suppose you have reviewer 2, and reviewer 2 holds some different preferences about what the ideal paper is. You might have to work a little bit harder to persuade that reviewer than when you think the reviewer is already sort of like in line with what you think would be. So it provides somewhat of an internal rationale for writing high quality legal opinions, right? If you have diversity of opinion, you might be incentivized to invest more in writing very high quality, very precise opinions, because you have to persuade your colleagues who have somewhat different views about what the ideal rule should be. And what I think is kind of interesting about that is that sometimes sort of ideology and judicial reasoning are kind of juxtaposed as being contradictory to each other. But in this model, that it's not that way, right? There's actually a rationale for writing high quality opinion that's not just focused on persuading external audiences, but it's also focused on persuading your colleagues. You have to get your colleagues on board, and that gives you incentives to write high quality judgments. So the implications of this is that on the one hand, sort of the probability of accepting state aid should increase as the median general panel judge is appointed by a more economically left-wing government. But this effect is also modified by the reporter judge. So the reporter judge can't determine everything. The reporter judge is always constrained by where the median panel judge is. But it matters. So if the reporter judge is more towards the right of the median, we're seeing the probability of accepting state aid decreases. And if the reporter judge is more towards the left of the median, the probability of accepting state aid increases. And I'm going to hand it over to Silje from here.
Thank you, Erik. So in order to test these two hypotheses, we are looking at, 646 annulment cases brought before the ECJ relating to state aid for the last 15 years, 1995 to 2020. For the most part, these cases come to the lower level general court, and then they are later appealed, so that we have 2/3 more or less before the lower level general court. Erik, I don't see the screen. Maybe it's only me. The nice thing with the annulment procedure is that this is a procedure where citizens, but also governments and other actors can bring their cases before the court and contest decisions or policies from the EU. And in this case, it's going to be the European Commission. And while state aid decision by the Commission obviously affect governments and their policies in relation to state aid, the procedure itself is dominated by companies. You can bring your case before the court as long as you have some kind of proven interest, usually economic, into the decision that was been made. And in 70% of the cases, there is a company that has filed the case. What is maybe even as surprising is that almost half of the cases, there is no government interference at all from the government whose policies is in question. That is, they do not file to support their own policy. They let things revolve in court.
Sorry, there seems to be an issue with the screen share. Is that right?
Yeah, I see. I'm not sure if it's on me or if it's your screen.
And was it okay before, or was it?
The one you presented was good.
Can you see it now?
Yeah, I can. I can also present without it. It's just will be asynchronous.
Okay.
Okay, so the difference from studies that have been done previously is that we're looking at the directional outcomes. That is, until now, for the most part, the researchers have been looking at who is winning. Is it commission? Is it the applicant? But not necessarily the policy content or the direction of the rulings. In our case, we're looking at pro-state aid rulings. That is, we're looking at the effects of the ruling. Would it be more liberal, letting people or governments continue state aid? Or would it be more restrictive? What we see is that the court ruled in favor of state aid in about 40% of the cases, which is fairly high. It is not necessarily in agreement with the Commission. In the pro-state aid rulings, some 65% of the cases were decided against the explicit wish of the Commission. What we're interested in is to link these judicial outcomes to judges' preferences. Judges are politically appointed. They're appointed by a government. We know the identity of the government and can calculate their preferences from manifesto data. We use 12 different indicators relating to the state's role in the government in order to come up with a a measure of judges or the appointing government's ideology. And in this way, we're connecting directly governments that are appointing judges to the outcomes. In the main models, we're then listing up all the judges that are on the panel and deciding the case. We identify the median judge and report their ideology. That's our first predictor. And then we identify the rapporteur and calculate the difference between the rapporteur or the median. We're controlling for government submissions because we know that the ECJ is responsive to government interventions. This being said, governments in general do not intervene in these cases, with the only exception of the one government, the effective government, whose policy is in question. And we could see this as a threat of non-implementation. And then what we find, we started out by expecting that we would see an effect of the median judge. And what we see is that as the median judge on the panel is moving to the left or to the right, the likelihood that the court is ruling against state aid increases or decreases, favor increases. And so if we look at a typical move, that would be something like the interquartile range, we would see a 32% decrease in support for state aid as the median on the panel is moving to the right. If we're considering the difference between the two most extreme panels that we are having the data, and remember these are the median judges, so this is not massive moves, we would see that we almost have a doubling of the effect. That is a 90% decrease in support for state aid as we're moving to the right. Then Erik also told you that we would expect the reporting judge to have an effect on their own, and we make the assumption that the only thing they can do is to move first and come with a good proposal and convince their colleagues not to write a counter proposal. What we see is that when we look at the additional effect of the reporting judge compared to the median, we see a 16% decrease in support for state aid as the reporting judge is moving to the right compared to the median panelist. There is more variation in the differences between the judges, the median and the reporting judge. And if we look at the difference, the biggest difference between the median judge and the rapporteur, we would see a 76% decrease in support of state aid, which is a massive move. So the key takeaways, I think, for today could be on some side, one hand that well, we can see the same conflict lines that divide governments. They also shape interactions at the court among the judges. And in contrast to a lot of the research that has currently been done, it's not necessarily a question of European integration. It's a question of economic left-right dimensions, states' role in the economy. It is not surprising, given that this is an economic court. And we can trace the appointing government's influence to all the way through the judges to the outcome. That is, even though we might think that governments do not care about influence or that they cannot move the median on the court, they do have an indirect effect on the outcomes from the court. And then we've been arguing to you that there are especially two decision makers on the court that we're interested in. We should care about the median panelists because there is a majority vote if judges do not agree. And we did see that there was an effect of the median panelists. And we also see that the reporting judge, the person who is in charge of preparing the case on behalf of the panelists, other panelists, has an additional effect and is able to move outcomes in their own direction. And this is because it's costly to come with an alternative proposal when the judge is proposing something high quality. And so I think it's about time that we start looking at the internal individual behavior within the court. We haven't done it much before. Thank you.
Fantastic. Thank you both for an excellent presentation, which I can tell from the chat has already sparked great interest among the audience. So I'll start with the question forwarded by Grain to Mark Pollock, who's been so kind to pass it on. So let me just read it out loud. As Grain notes, the paper doesn't report whether there are any differences in outcomes observed between the ECJ and the General Court. This would itself be interesting, since the courts have different types of caseloads, and since member state considerations in nominating judges might therefore differ across the two courts, being more economically focused for the General Court and perhaps broader for the ECJ. Have you given any thought to the ECJ General Court distinction, either in theory or in your results?
We did not agree on who's going to answer, Erik.
I think this one is yours.
Okay. Yes, we've given thought to the difference between the Court of Justice and the General Court, for sure. There are a lot of differences between them. I'm not sure if I understood the question correctly. Are the differences in outcomes, or is the question more related to, are the differences in the influence that judges have on the outcomes? That is, indeed, we have a lot over the period. The ECJ has been, well, the Court of Justice in general and General Court in general have had a very high caseload at some point. They had a few reforms. They now have a low caseload. So we have a lot of variation to leverage in terms of how well they can monitor each other across the two courts, but also within the courts. And I think I would go as much for the within court variation, if that's what we want to look at. The same goes for the fact that especially the Court of Justice have moved away from these bigger chambers and the use of a hearing on a general advocate general, which are also like monitoring tools for colleagues. So I think, yeah, we're giving thought to it. We're going to think more about it.
Super. Then a question from Andreas Hoffman. There are a couple, but I'll start with his first one. Could you say something about the coding of outcomes? Is this straightforward?
Fairly, for the most part, yeah.
And as a follow-up to that, then, on what basis you code government ideology?
We don't. Oh, sorry. The appointing governments?
That's the question.
Yes. Okay. Well, the appointed governments are known, so we can connect them to party manifesto data without too much ado. So that's not much of a problem.
All right. Then Anfanakin has a question. What is the role of the Advocate General ideology? Those opinions have a high influence on the court. And the second question, can you see empirically some change along the timelines? As Erik mentioned, there is a general shift to industrial policy by left and right. And thus one would expect that more recent decisions are more state aid friendly.
Sorry, I'm trying to read well, there is a fluctuation over time going up. Yes, there is a fluctuation over time, but there's also a bit of a selection bias into the court. We can only see the cases that are brought to the court. But yeah.
All right.
So let me just also say something here that so on the AG, most of our cases are from the General Court, so there's no AG in a lot of those cases. And over time, we don't have the COVID period in our analysis, and we don't have the more recent sway towards green industrial policy. I do think there's undoubtedly going to be a whole swath of new cases that maybe have some different characteristics, and be really interesting to look at that set of cases and to see how if our pattern sort of still holds. Also, because I think more recently we've seen some more right-wing governments being quite enthusiastic about industrial policy as a way of doing. Of shaping policy, so that might change a little bit what we find, but I'm not sure yet. So I think that would be very interesting.
So following up on that, and there's Mark Pollock has another question from himself this time. So he writes, in Erik's and Silje's theory, there's considerable work being done by the quality of the judges' rapporteur's draft ruling, so much so that I expected it to be a variable in the empirical analysis, using some proxy like the number of case citations in the decision to determine whether the judge rapporteur produces the higher quality decision in response to a greater distance between herself and the median judge on the panel. But in fact, the quality of the ruling appears to be an unobserved variable, assumed to be relevant but not observed. The question is, have you thought about subjecting your assumptions about quality of decision to empirical analysis? And if I may add, a question of whether you've thought about looking at the language specifically.
Yeah, so let me speak to that a little bit, because I think one of the reasons why we don't have a fully finished paper, I think, is because we kept tinkering with the theory, and it's also one of these cases where I think there's actually more interesting implications and potentially observable implications than we've highlighted here, and that we could really further explore, because we explicitly assume that, of course, every opinion consists of both this sort of cut point that decides where the case is going to go, but also the quality, and there might be. I've done this in the past. I've done some work on sort of proxying judicial, or the quality of judicial reasoning based on various methods. So that could be done here too as a separate outcome. It also opens up the possibility of analyzing a third actor, which is the president of the court, who actually appoints these rapporteurs. And actually, Silje has done some work on this, and there's been some other work too recently showing that it's not equally distributed among Court of Justice judges, right? So there are some judges that get a lot of cases as a rapporteur, and some judges that get very few. And first of all, we might have some idea why, because if you don't want to appoint the extremist, because in our model then talk about that, they're not very influential, they're not really incentivized to write really high quality opinions. And you have a lot of incentives to appoint judges who will write high quality opinions if you want to preserve consensus on the court. If you care about perhaps institutional legitimacy, which the president of the court might be especially concerned by, maybe more than other institutional actors. So it also opens up the possibility to try and understand the role of that actor, I think, a little bit more, because it's a very influential actor on this court. So the short answer is, like, yes, we've thought about it, but we haven't yet implemented this. I'm not sure. It may also be a separate paper. I'm not sure, but I think it's potentially interesting to try and understand sort of how variation in judicial reasoning might emerge from the kind of processes that we talk about.
Anything to add, Silje, before I move on to the next question? Super. So the next question comes from an anonymous attendee, and the question is, what's the object of ideology? It can still be the idea of state sovereignty along state market interventionism. Prohibiting state aid is pro-internal market, pro-EU, and allowing it is pro-MS crudely. How to differentiate, or is it not a problem because both point in the same direction, especially if the state aid cases at the Court of Appeal are appeal cases? There you are also tapping into the question of specialization. The general court is a competition law expert and judicial hierarchy. How much will the court defer to the general court?
I think it would be interesting to look at other subject areas as case than state aid, of course, where the EU has regulatory powers more, and you would have basically the regulator being at the EU level, and you would have less of that problem that the two dimensions could collapse. I don't think it's the case here, simply because we are reliant on governments to appoint judges with their own ideology for making this decision or this connection to the outcomes, and we find no correlation between the variation in overturn of judges and governments' integration policies. There is no correlation, and so yeah, it's hard to know, but I don't think they collapse here.
Yeah, and on a more conceptual basis, I think I'm always a little bit skeptical about purely sort of procedural understandings of sort of pro or anti-European integration, just because of what European integration means or might mean, could mean, means something very different depending on your sort of substantive ideology. So understanding or equating European integration with a single market where governments cannot intervene into the economy is a very particular understanding of what European integration means, right? And even with the far right now, you're seeing that the far right objects to some aspects of Europe as it has materialized, but actually would like sort of European integration just to be different, right? So it's not that they're anti-Europe, it's that they want European integration to take very different forms. And so in my own understanding, I think it's typically more interesting to focus on these sort of underlying substantive ideological dimensions that can be related to pro and anti-Europe, especially in the context of the single market, but also to be very aware of that sort of a very sort of pro-single market view is only one way to understand sort of a pro-European integration view. There are other ways of thinking about that.
Super. All right, so from Steve Charuvu, Erik and Silje, this is great, and about time someone adapted the case-based framework to the ECJ. Is there any way you've thought of to empirically proxy costly effort here? It seems like this would have clear empirical implications for how influential rapporteurs should be.
Well, the answer is yes, for sure. This is the early draft, and yeah. As I said, the workload of the court has varied quite a lot over time. So it's a nice court to test this implication in a way we couldn't do, for example, for the US Supreme Court, because they decide on their caseload anyways, in a way that the court doesn't. So yeah, for sure.
All right. Now from SG Yildiz. This is a great paper and a very interesting approach. I have two quick clarification questions. Following up on a point in the government ideology question, how do you measure the ideology of coalition governments? And does time matter, which I guess in a way you've already touched upon, but I suspect the persuasiveness of the rapporteur might increase as they become more seasoned within the organization. Do you control for the time of their tenure? That you have not answered yet.
We calculate the final calculation of the ideology is a weighted average according to seat size in parliament. So we follow fairly classical calculation of these preferences. Does time matter? Yeah, that's a good question. I would expect it would matter maybe more before the ECJ or the Court of Justice than the General Court. It's a good question. No, we don't control for it.
All right. Jared Conway writes, thank you for the papers. To what extent do you think the rules, when subject to legal reasoning on state aid, leave scope for individual judicial preferences for or against the provision of state aid? Secondly, do you relate quality to inherent legal method or persuasiveness acceptability to audiences, which taps a little bit into some questions about the reasoning previously?
Yeah, maybe I can say a little bit about this, although I should qualify this that I'm not really an EU law expert. So, but I'll answer it in a little bit more of a conceptual way. So first on what quality means in this context. Quality in this context means that the rule is more precise to others and therefore more likely to be implemented close to its intended target, right? So it captures the idea that, so say if you're an author of a legal rule, the effectiveness of that legal rule is still going to depend on how others implement it, how other courts sort of see it. And the idea here is that if you write you can write a rule in a way that there's going to be less variance on how this rule is going to be interpreted rather than more variance, and that's what quality really means in this particular context. So it's not catered necessarily towards compliance audiences per se, but it's really about the precision of the rule. On is there scope for individual judicial preferences? We can answer that empirically. Clearly, yes, at least that's what our findings sort of suggest. But also, we suspect that the kind of cases that come in front of the court, I mean, you only really challenge a ruling by the commission if you think that there's at least some possibility that the court might rule differently, I would imagine. I don't really see strong incentives in this particular setup otherwise to file a case. So we're assuming that the cases that we actually observe are ones where reasonable people could disagree about whether a state aid instance should or should not be allowed. So that's a very empirical answer.
Super. So from Kate McNamara, this is a fascinating paper. Thank you. I'll definitely take up Erik's point on the coding of government left-right cleavage around state aid post-2020. There's a large literature emerging that argues that there has been a fundamental shift both at the member state and EU level towards market activism, both post-pandemic Ukraine, across political parties, albeit for different ideological reasons, green and digital transition, geopolitical competition on tech, etc., etc. It would be terrific if you could get data on the last 3 or so years and see if that is translating yet to the court. It would open up lots of interesting points about the politics at work and at what arguably is a critical juncture for the EU's market making. So point given. I don't know if you'd like to respond to that.
I'll just say one thing. So I really do agree, and it sort of speaks to my earlier point about sort of thinking of pro-single market as not being the same as pro-European integration. You could think of pro-European integration as shaping a common European response to the Russian threat, shaping a common European response to the threat of climate change. And that sort of, there's a role of state intervention. Typically, it's justified by achieving some kind of public good or public outcome, right? And so how you interpret that really, I think, depends on your ideology about how those challenges might be met and what the role of Europe is in meeting those challenges. So I do think there is a bit of a shift in the landscape on what is desirable, what is a desirable role for the state and the economy is. So I'm sure at some point we'll gather more data.
Sounds good. So from Anne van Aken, on a broader note, Erik, you've looked at gender differences at the ECTHR and found that it only makes a difference in discrimination cases, the 21 paper. So would you say that more generally ideology, gender, etc., are mirrored in the output, that is the decisions, only when the input, ideology, etc., is relevant for a specific case? Can you then formulate a more general hypothesis or theory on judging? How far does psychology and biases play a role in all of this?
That's a hard question. I'm not sure. First of all, thanks for raising that. We haven't actually looked at gender in this context yet, which is of course hard because it's also a little bit endogenous to parties. But yeah, I mean, I think so. Certainly our story here is premised on that there is some kind of a link between what political parties and governments care about and what kind of cases are before the court. And otherwise, this kind of accountability mechanism or sort of link between judicial appointments and the outcomes of cases shouldn't really exist. In gender, and that's a broader finding actually that generalizes to the American judicial behavior literature as well, that it seems to matter only in a subset of cases and not in other cases. And one story is that might be linked to experiences, for example. I think that's a slightly different theory than the ideology theory, which is more sort of about where, well, maybe it could be comparable. But I'm not sure. So yeah, I think I'll stop there. I'm not sure if I'm ready yet to formulate a general theory of judging in this
on
form.
the go. Sounds good. All right. Mark Pollock and has another follow-up questions, but it's more to the quality dimension, so I'll return to that. But in the meantime, let me ask a question from Mark. I'm wondering if Erik and Silje can conclude by talking about the scope conditions for the theory. State aids are a great case for the theory because it clearly relates to economic ideology, and we have claims for annulment coming from a variety of actors. How far would you expect this economic ideology argument to extend, and what kinds of other cases by issue area or by the identity of the complainant would be good places to look for those effects?
Who's answering?
Do you want to take that one, or?
Sure.
I'm happy to, but I think you might give a better answer here.
Huh?
I think you're better equipped to answer this one.
Well, I'd say I would go for competition after taking Manhattan. And what is it? No, first we take Berlin, and then we take Manhattan. I would go for a competition, I guess. And single market. For the most part, EU policies where the role of the governments in the economy is of issue. And then the question is, how much does this relate to free movement of people? I'd say that's an empirical question. I wouldn't know.
All right. Nothing to add, Erik?
No, I think that's right. So, I mean, if we're just that, the basic point is simply that if we're talking about economic ideology, would obviously have to be case, or we're measuring very specifically the role of the state in the economy. That's actually what we code from the Party Manifesto data. There would have to be cases that concern that issue. So that's really what, and so competition policy cases, single market cases are the obvious examples, which is a very large part of the output of the court.
Sounds good. So I have a clarification question from Anfanakin, which relates to the quality dimension. The state aid rules are, of course, the same for all cases. So do you mean the rules formulated in the case, or is quality not rather a question of use of legal methodology and thus being legally convincing? That was also my understanding. If the latter is the case, does it matter what arguments are deciding the case, effective wording, etc.?
Yeah.
Good question.
Yeah, it's a really good question, and so it's definitely about being convincing. I don't know. So legal rules, I do think that within the whole subject matter of state aid, there are of course numerous legal rules that are important and that can define sort of what exceptions are allowed and are not allowed. One thing I've been thinking a little bit about, but I don't want to open up that black box, is of course the rule of precedent here, right? Which is, I think, very important because cases are and can be linked to each other. So it could be that, of course, the judges feel constrained by decisions that have been made earlier, which I think is opening up some interesting theoretical and empirical challenges that I think I want to bracket for now, but they are important.
And maybe I should, yeah.
Yeah, please go ahead. Please go ahead.
A lot of these cases are about discretion. That is, it's not as much the rules. A lot of these cases, they go back until 1995, right? So a lot of these cases are also instances where member states or governments have implemented some state aid according to some old rule exception they got when they joined the EU, and they basically put new policies into that old policy, and I hope to get away with it. And then they're found out by the Commission. And these are cases, an example where there is a lot of leeway in the interpretation.
All right, we have one question. Maybe a small one at the end as well, but that relates to the hidden actors at the courts. So judges typically defer the writing to their clerks, an anonymous attendee writes. I would like to hear how we can still ascribe the cost of opinion writing to the judges. What does the original model say about this, given the US Supreme Court judges also have clerks?
Well, it's an opportunity cost. If you set your clerk to write the opinion of another judge, you don't get to help to write the other judgments you're responsible for. So regardless of whether it's the judge or the clerk, you're allocating time and resources towards something else.
And I do think, I mean, so I think this is really important. And I mean, I've studied the European Court of Human Rights more intensely, and the role of the registrar there is also super important in drafting judgments. I would, though, say that even if judges, even if they defer a lot of the writing to clerks, they certainly give direction to clerks in how to write the judgments. And, you know, and I'm assuming that different judges are a little bit different in how deferential they are to clerks. I find it a really interesting phenomenon, just how uneven the allocation of reporting judge responsibilities is across the court. There are really judges that get asked almost never to do this, and there's judges that get asked all the time. I think all of them have clerks. So why is this, right? So that's something I think we need to still figure out. We don't have it in the model. The model is abstracts away from this, even though, of course, we know that clerks are responsible for contributing to this. But, you know, it's not like a judge would just, or at least a highly qualified judge would just defer everything to their clerks. They would also direct that work, check that work, and probably have their own input on key passages at least, right? Not maybe on everything or the citations or so, but certainly on key aspects of a judgment.
Super. We're approaching the end, so so unless you have anything that you're burning to say before we close off the session, this is your opportunity.
So many interesting questions. Thank you for engaging.
Yeah, thank you, Susanna. Thank you, Mark, and thanks everyone for those great comments. This is really useful. We're just starting out on this, so very useful feedback.
Super. So thank you to Silje and Erik for presenting your work, and to everyone in the audience from near and far for excellent questions. This was the fourth and final session of this spring's International Law and Social Science speaker series. So if you came in late today, or if you've missed one of the previous sessions with Sergio Pugh, Taylor St. John, or Shira Krebs, I encourage you to go to ASIL's YouTube channel and find the recordings there. It's a goldmine of fantastic presentations of research that excellently integrates social science and international law, accompanied by some really great discussions. So thanks for tuning in today. The speaker series will return after the summer, and we'll see you then. Thank you.